Hello and welcome to this video on domicile inquiries. My name is Helen McGhee and I'm a Director and Chartered Tax Advisor at Joseph Hage Aaronson, and I specialise in pre-litigation settlement strategy for tax disputes, typically for UK res non-doms, but I advise on a broad spectrum of UK tax issues for individuals and indeed corporates. In this video today, I'm going to be talking about who might be vulnerable to an HMRC inquiry on domicile and how best to equip yourself to deal with one if it arises. So what kind of non-UK domicile taxpayer might be vulnerable to HMRC scrutiny? We're really talking about taxpayers who HMRC will say, as a matter of law, have somehow acquired a UK domicile of choice. This might have happened because they have been in the UK so long that HMRC do not accept that they have not settled here permanently or indefinitely. Possibly because they no longer have any ties in the country where they claim to retain a domicile of origin, and HMRC does not accept that there is a reasonable contingency that suggests that they will leave. The case of Proles versus Coley is worth a read on this point. It was a case under the 1975 Act. Domicile, of course, is not always just a tax issue. These kind of taxpayers are what I would refer to as the long-term UK residents who might be under scrutiny. HMRC will also have their eye on any Stuart Gulliver type scenario. If we remember the 2017 first tier case of Gulliver, what we're referring to here is those with a UK domicile of origin who left the UK many years ago and say have acquired a domicile of choice elsewhere, but now want to return to the UK, and HMRC do not accept that their presence elsewhere, possibly for a number of years, was enough to initially displace a UK domicile of origin, often just by virtue of the fact they're now returning, albeit for unknown work, health, whatever reasons. But HMRC will argue that they never intended to permanently settle elsewhere. These are the returning UK DOMs that might be vulnerable. So you have these taxpayers with a weak argument that they do not have a UK domicile of choice, as we've just alluded to, but also vulnerable to attack is the taxpayer with a weak non-UK domicile of origin. Now that tends to be second or third generation immigrants who have never lived outside the UK, but inherited a non-UK domicile of origin from their father, and the taxpayer maintains that he or she has not yet acquired a UK domicile of choice. These are the weak non-UK domicile of origin taxpayers who may be vulnerable. The case of Henderson versus HMRC, which is a 2017 case as well, speaks to that, where HMRC really delve into the immigrant parent's domicile and will consider their intentions upon arrival in the UK. If the parent never intended to leave the UK, then the taxpayer may have acquired a UK domicile of dependency, which became a domicile of choice at 16, and this in turn cannot be lost until he physically leaves the UK. So there's sort of three lines of attack there that HMRC won't shy away from. Our long-term UK residents, our returning UK DOMs, and those with a weak non-UK domicile of origin. So let's have a think. How can taxpayers protect themselves against or be ready for or alert to the prospect of an inquiry? I always tell clients that it's very important to keep an up-to-date running chronology of key life events. For example, the date they acquired a UK property, and examine the impact of those life events. We ought to look at naturalisation and citizenship, and whilst this is not a deciding factor, it is certainly a relevant factor when it comes to domicile. And in December 2020, the Home Office made a clear statement that if an individual applies to be a UK national, but for tax purpose says they are only here temporarily, then that may jeopardise the citizenship application. If, on the other hand, saying that in an application that they intend to stay here permanently, then that could lead to an acquisition of UK domicile of choice. There's real potential for conflict here that we need to manage. Taxpayers might want to consider alternative routes to staying in the UK. I used to advise considering the prospect of an investor visa, but obviously those have been withdrawn. But it's important to speak to an immigration advisor, really. I also urge taxpayers to look through past correspondence with HMRC and any information or statements that might have been made in the past. For example, if the taxpayer said he would leave at 60, did he do so? And if not, why not? You know, really stress test any weaknesses. If the taxpayer is relying on a contingent event as to when they will leave, such as retirement, realistically, when will this be? And again, test the contingency. By the way, the contingency must be entirely voluntary, of sufficient substance and precise and ascertainable. In terms of previous correspondence, I think it's important to be wary of over-reliance on a previous domicile ruling. You know, HMRC have on numerous occasions been allowed by the court to resile from such rulings. We saw this again in Gulliver. I think it's important to know how much tax is at stake. Be aware of the impact that an inquiry will have on the taxpayer's tax position. You know, when and where have there been trusts set up, or where has there been any reliance on transitional relief such as 2008 rebasing, and when have large capital payments been made out of trusts? Note the potential for HMRC to go back 20 years, by the way, from the date of any chargeable transfer if no IHT account has been delivered or a chargeable asset has been omitted. I'm referring to section 240 of IHTA 1984. There is a list of the types of documents that might be requested on a domicile inquiry at it's RDRM 23080. So if there is a perceived weakness or risk, you know, start to gather some good quality evidence. It will ultimately save time and costs later. How should a taxpayer or his advisors deal with HMRC inquiries when they arrive? Don't forget that the onus of proof in relation to domicile is on he who asserts the change. So it is often for HMRC to show that the taxpayer has acquired a UK domicile of choice. HMRC needs to demonstrate that the taxpayer has acquired the requisite intention of permanent or indefinite residence in the UK. One of the questions I often get asked is, should the taxpayer go for an interview? Now, interviews are about HMRC building their case. So the big thing is, make sure you know your client before they embark on an interview. By the way, also know when was the last inquiry into domicile and have circumstances changed since then. You know any hobbies or interests. Are these actually compatible with leaving the UK? What about friends, social ties, large business interest? How much time is actually spent in the place of claimed domicile, and is there a home there? Make sure nothing is new to you as the advisor come the time of the interview. Certainly, I would say avoid being straitjacketed into anything when answering a question, and never saying anything to HMRC that you can't evidence. What limits are there as to what HMRC can ask for during the course of an interview? There is obviously nothing to be gained from any taxpayer being obtuse and uncooperative during the course of an inquiry, but it is so important to know when to close off avenues to HMRC, and also to know the legal position with respect to formal requests for information under Schedule 36. Under Schedule 36, HMRC can only ask for information, by the way, for years where there is an open inquiry, that is reasonably required to check the taxpayer's tax position. Think about how burdensome it would be to provide the information against how important the information is in deciding the correct tax position. What we're seeing in domicile cases is HMRC using Schedule 36 notices to ask for evidence of what the taxpayer's non-UK income or gains were over the past X number of years to decide if the quantum of tax makes the case worth pursuing, really. You know, if we think back to Henkes, the first tier tribunal decided that it did have jurisdiction to determine if the taxpayer was domiciled
in order to establish if the information was reasonably required. Great, but in Perlman and Redston said the first tier said that it did not have the jurisdiction, due in large part to the voluminous amounts of evidence that would need to be adduced in such cases, which presented a real problem. The taxpayer is relying on the fact that he is not UK domiciled to say the information is not reasonably required, but the first tier won't in turn decide on domicile, and so the taxpayer loses his appeal against the Schedule 36 notice. I suspect there'll be quite a lot more to be said on this issue. You know, we know that the first tier has jurisdiction to decide a question of law and a question of fact. So it seems ridiculous to me that they say they have no jurisdiction to determine a question of mixed law and fact. It's wholly unsatisfactory to have to resort to public law remedies in this instance. So watch this space.